Good evening, everybody, and welcome to the first lecture of the spring in the Amicus Curiae lecture series. As you probably know, because I see many familiar faces, this series is designed to consider issues related to the Constitution, and we want to share our experience not just with the university community, which is well represented here, but also with the local community. So thank you for coming out, and we're happy you're here. As you walked in, you got a form from the West Virginia Humanities Council, I hope. They've asked us to have those filled out and sent in afterwards, so if you could do that, we would appreciate it. Hey, it is my privilege tonight to introduce to you Professor Frederick Schauer of the University of Virginia Law School. Professor Schauer has actually several students who've traveled here to hear him tonight who've had him as a professor before, and that's wonderful. I'll also show you a little bit of my green and tell you that the Associate Dean of WVU's Law School called me and told me how jealous she is that he's here, and that made me feel good. Professor Schauer earned his AB and an MBA from Dartmouth. He's a graduate of the Harvard Law School, and most recently, before moving to Virginia, he taught at the John F. Kennedy School of Government, where he also at times acted as dean, an academic dean. He was there for 18 years, and during that time he taught at the Harvard Law School as well. He served at other prestigious institutions, including the University of Michigan, the College of William and Mary, the law schools, of course, and before that, our own West Virginia University. Professor Schauer is a fellow of the American Academy of Arts and Sciences and a former holder of a Guggenheim Fellowship. He is a prolific writer. He's written several books and actually roughly 200 published scholarly articles and reviews. He's a founding co-editor of the Journal of Legal Theory. He served as chair of the section on constitutional law of the Association of American Law Schools, and chair of the Committee on Philosophy and the Law of the American Philosophical Association. He has taught, lectured, or advised on legal and constitutional issues in more than 24 countries. And his scholarship has not just been prolific, it's been the subject of a book in its honor, and he's had several scholarly journals dedicated to his scholarship. Obviously, we're very lucky tonight, and I'm very pleased to introduce to you Professor Frederick Schauer.
Thank you very much. I am delighted to be here. I want to thank Patricia Proctor and David Pittenger for arranging for this whole event. It was noted in the introduction that some number of my former students from various places are here. That unfortunately creates an enormous degree of pressure because over the period of 3 decades, more or less, all of the boring moments get forgotten. All of the bad grades get forgotten. The only thing that's remembered is the occasional funny line or two. So now there are people here who think of me as funny even though I am not, and the pressure on me to be funny even though I am not a funny person is quite enormous. So with advance warning that I am not going to be funny, and those people who remember me as funny from 30 years ago are mistaken, let me turn to the matter at hand. So, for most of you, I'm not entirely sure of why you came tonight to hear me talk about does the Constitution matter, but I'm pretty sure that it was not to hear me talk about the 27th Amendment. Nevertheless, you are stuck in your seats, and I'm up here, so I'm going to take a few minutes briefly to talk about the 27th Amendment, and then I'm going to explain why it is relevant to the matter at hand. So first, let me quote the 27th Amendment in its entirety. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. The purpose of the amendment should be pretty clear. It was designed to prevent members of Congress from raising their own salaries. The theory behind it is if you want to raise your own salary, you have to stand for election before you actually get the money that you voted to give to yourself. What is now the 27th Amendment was first introduced and first approved by both houses of Congress in 1789. It turns out that it was one of the first 12 amendments proposed to the Constitution, but for a long time, and I will explain the history in a moment, it was never ratified. So if there are any journalists in the room, or anybody who's ever listened to a journalist, or especially anyone who's ever listened to a journalist talk about the First Amendment, you have undoubtedly heard journalists talk about something to the effect of, there's a reason why the First Amendment is first. It's most important. The Founding Fathers knew that. Well, next time someone says that to you, tell them they're wrong. What is actually the First Amendment started out as the third. The first two were not ratified. The first one dealt with the sequencing of congressional terms. The second one is the one that has now become the 27th Amendment. Became the 27th Amendment in 1992. It was approved in 1789 or shortly thereafter by both houses of Congress. A couple of states ratified it, then everybody forgot about it for a long time. Every couple of decades or so, another state would ratify. And then a University of Texas graduate student named Gregory Johnson in 1982 discovered the unratified 27th Amendment, discovered that unlike more recent constitutional amendments, it did not contain a time limit for the ratification process, and therefore came to the conclusion that first of all, it was a good idea, and second of all, it was still a live issue. So he started to agitate for its ratification and was successful. Michigan was the 38th state to ratify it, ratified in 1992, and this is now the 27th Amendment to the Constitution. Now, why is it relevant? Fast forward to February the 27th, 2011. Events that are familiar to all of us of more roughly a year ago. Budget impasses, we still have budget impasses, but budget impasses of a year ago, and serious risks of a government shutdown if something was not done about the budget impasse. In the face of this, Senator Barbara Boxer of California proposed that the members of Congress should take no pay until the issue was settled. And she said, if the government is going to be shut down, then we should not accept any salary. Our salary should be cut because of this. Whereupon Senator Leahy of Vermont, the same party as Senator Boxer, so this is not a partisan dispute, Senator Leahy of Vermont stood up on the floor of the Senate, took out his copy of the Constitution, and read the 27th Amendment. No law varying the compensation for the services of the senators and representatives, although it may have been intended to prevent them from raising their own salaries. The words clearly say varying. There's no doubt about it. No law varying the compensation for the services of the senators and representatives, and so on. And Senator Leahy said, Senator Boxer, fellow members of the Senate, this would be a wonderful political symbol. This would be a very important thing to do. I wish we could do it, but if there is anything that is clearly, unmistakably, textually, literally prohibited by the 27th Amendment, this is it. There are 100 members of the Senate. No one agreed with Senator Leahy. The resolution thereupon passed with no one supporting Senator Leahy's position. The view that the Constitution, in language unmistakable to everyone, prohibited this had absolutely no effect. Indeed, about a month ago, in the course of the current campaign for the United States Senate in Virginia, George Allen, former governor, now running for Senate in Virginia, still, in the modern vernacular, did not get the memo, or maybe got the memo about the politics but didn't get the memo about the Constitution, said, if members of Congress do not pass appropriation bills on time, we should withhold their pay. Now, the story is a little bit more complicated. When Senator Boxer was expressing her annoyance at Senator Leahy for daring to mention a constitutional prohibition in the course of a Senate debate on a matter of high political salience, Senator Boxer said, well, this is not unconstitutional. It would not be unconstitutional unless and until some court says so. So that view would say the Constitution is just the raw material. No act of Congress, no act of a legislature, no act of an executive is actually unconstitutional unless some court says so. So it is not the Constitution itself, according to this view, that renders things constitutional or unconstitutional, but court judgments that render things constitutional or unconstitutional. So now let me tell a different story. This story goes back in its beginning to 1989. In 1989, a young man with a strong, long list of grievances and a loose grip on reality, named Gregory Johnson, decided that he was going to protest against a large number of government practices by burning an American flag. He was prosecuted for desecrating the American flag under a Texas law that prohibited flag desecration. Case wended its way through the Texas courts and finally got to the Supreme Court of the United States. In 1989, the Supreme Court in Texas versus Johnson upheld Gregory Johnson's right to burn an American flag, concluding that burning an American flag was a form of speech and a form of political protest clearly protected by the First Amendment to the Constitution, technically as applied to the states through the 14th. Several months later, Congress, outraged like large numbers of Americans by the result in Texas versus Johnson, passed a federal law virtually identical in wording to the one that had been invalidated by the Supreme Court in Texas versus Johnson. In between the time that the Supreme Court decided Texas versus Johnson and the time that Congress passed the Flag Protection Act of 1989, no justice of the Supreme Court had died or retired or resigned. Very little time had passed, and it was exactly the same issue that the Supreme Court had decided in Texas versus Johnson. In the face of the same justices deciding the same issue within a very few months, and therefore in the face of almost certain, and maybe I should take out the word almost, in the face of certain invalidation, the vote for the Flag Protection Act of 1989 in Congress was 380 to 58 in favor in the House of Representatives and 91 to 9 in favor in the United States Senate. And shortly thereafter, in a case called Eichmann versus the United States, the Supreme Court did exactly what everyone expected, and they invalidated the federal law. I've done a little bit of soft empirical research on this question, with a little bit of focus on the 471 members of Congress who were willing to vote for a law that was certain to be declared unconstitutional, and willing to vote for a law that a very recent Supreme Court decision had said is, for all practical purposes, unconstitutional. To the best of my knowledge, none of those 471 members of Congress suffered any electoral disadvantage whatsoever as a result of that action. None of them were voted out of office. As best I can tell, none of their opponents, insofar as they had opponents in following elections, none of their opponents dared mention this in a political campaign. It turned out that voting for an unconstitutional law was what, in a different context, the British call a free vote. This did not involve any negative political consequences whatsoever. Indeed, we see a similar scenario with respect to a series of laws dealing with child pornography. In 1982, the Supreme Court decided a case called New York versus Ferber, saying that because of the interest in protecting children that would be used in making child pornography, child pornography could be made a criminal offense by the states and by Congress, even if the material was not legally obscene, a technical term that does not include a fair amount of child pornography, including child pornography that abuses children in order to make it. But the Supreme Court in Ferber said the interest in protecting children against this kind of abuse is so great that we will not require a showing of legal obscenity. But because the court was so concerned about the actual children used in making the material, it made it clear that there had to be children involved in making the material. This was not that big an issue in 1982. It became an issue a couple of decades later when, through the miracles of modern technology, it became possible to produce virtual child pornography without using any actual children. The United States Senate Judiciary Committee had hearings on this bill. A large number of so-called experts, I use so-called because I was one of them, a large number of so-called experts from different political parties and different political ideologies and different political persuasions all said to Congress, this is not going to fly. The interest is certainly well-meaning. The interest is certainly important. Given the 1982 case and the intervening cases, child pornography that does not use actual children, that is virtual and does not involve the abuse of actual children, cannot be prosecuted unless it's legally obscene. As with many of the other things I and other so-called experts say, this had absolutely no effect on the members of Congress or on the members of the Senate Judiciary Committee who proceeded to approve the bill. Congress passed it overwhelmingly, and it was struck down by the Supreme Court of the United States, and subsequent variations have been struck down by some number of lower courts as well. Once again, the existence of seemingly clear precedent doesn't seem to have made very much of a difference. Now, the obvious explanation of these two examples has something to do with the enormous political power, I say this ironically, the enormous political power of the flag-burning and child pornographer lobby. But it is clear that these are issues in which the politics trumps the Constitution, the politics trumps the existing Supreme Court precedents. Now, to be fair, this view has a quite distinguished provenance. Thomas Jefferson refused to enforce the Alien and Sedition Acts, saying that he, as president, had his own constitutional responsibilities. Jumping ahead 50-some years, Abraham Lincoln in one of his debates with Stephen Douglas and on some number of other occasions, said that as president he would not accept the authority of the Dred Scott decision. And he said he would not accept the authority of the Dred Scott decision because he had his own constitutional responsibilities as president. He understood that he had to follow the Constitution, but he would follow the Constitution as he interpreted it rather than as the Supreme Court interpreted it. Franklin Roosevelt took the same position in the later years of the New Deal. After the Supreme Court had invalidated some number of items of New Deal legislation, there was a suggestion, apart from the court-packing plan, that may or may not have produced changes in the views of the justices. Historians still debate this. But there was the view that the Supreme Court was striking down all of this legislation either as an infringement on individual liberty in violation of the Fifth and 14th Amendments, or as beyond the powers of Congress under the Commerce Clause. Roosevelt then said to Congress on some number of occasions, don't worry about that. Your job is to pass the legislation that you think is good policy and constitutional. Their job is to strike it down if they disagree. They shouldn't do your job. You shouldn't do their job. Don't worry about that. Somewhat more recently, Attorney General Edwin Meese in 1985 made a quite famous speech, quite controversial at the time, in which he urged the states not to treat Supreme Court opinions on issues of abortion and school prayer in particular as binding on them. Attorney General Meese's position was that the Supreme Court's decision in Cooper versus Aaron in 1958 was the problem. In 1958, in the wake of the Little Rock, Arkansas desegregation controversy, Governor Faubus of Arkansas essentially reincarnated the interposition position and said, Brown versus the Board of Education was decided by the Supreme Court, but it's not binding on the state of Arkansas. Some number of people, including Attorney General Meese in 1985, including people on the other side of the political aisle metaphorically, like Larry Kramer, Dean of the Stanford Law School, have also taken the position that Cooper versus Aaron was a mistake. That constitutional meaning should be determined either by the political branches or by the people in public deliberation. Indeed, in one of the most recent position papers of Newt Gingrich, the Cooper versus Aaron was wrongly decided position has surfaced once again. There aren't that many issues in which the dean of the Stanford Law School and the Tea Party are of one mind, but the view about popular constitutionalism is one of them. And all of this is of the same piece with, does the Supreme Court's interpretation of the Constitution matter? So now let's go back to the 27th Amendment for a moment and take stock of where we are, or where I am. So, the text of the Constitution doesn't matter unless the court makes a specific ruling. But the court making a specific ruling doesn't matter either. And if neither the text of the Constitution matter to political figures, nor what the Supreme Court says about the text of the Constitution matters to political figures, what is the relevance of the Constitution to political figures as they make their political judgments? I've been talking mostly about the Constitution, but let me give a few more examples just from law more broadly. One of them is very recent. As some of us in the room remember, in 1973, Congress, in the wake of the Cambodia incursion, passed something called the War Powers Resolution. The War Powers Resolution requires that if the president is going to introduce American troops into hostilities without an advance declaration of war or equivalent approval from the Congress. The president, first of all, is required to consult with Congress, and second of all, that the hostilities must cease after 30 days, and then there's another 30-day period, unless there has been explicit, no doubt about it, congressional approval. In the wake of the American incursion into Libya, President Obama and the Obama administration took the position that sending drones over Libya and dropping bombs did not count as hostilities. And these did not count as hostilities because there was no danger to American troops. This position was widely mocked on all sides in all directions of the political spectrum. The view behind the mocking was dropping bombs on people and things in other countries is a hostility according to the literal meaning. If it were otherwise, if I sneak up behind someone in a dark alley and hit them over the head with a lead pipe before they see me, there's no possibility of their retaliation, but it would be absurd to say that this was not a hostility. Indeed, even the administration's own Office of Legal Counsel said that this was an untenable position. But Harold Koh, former dean of the Yale Law School and now legal advisor to the State Department, was willing to defend the position before the Senate Foreign Relations Committee. And as a result of that testimony, there was about 2 days of active controversy or active discussion in the national press. The 2 days is important because it's only 2 days. Broadly speaking, Libya has sort of worked out the way the administration wanted it to. I don't want to offer a foreign policy judgment or a political judgment, but a pretty awful person was removed from power and no Americans were killed. If, to oversimplify, we understand that as things sort of worked out okay politically and sort of worked out okay as a policy matter, it may explain why after the 2 days that I have just mentioned, there has been absolutely no attention whatsoever to the illegality and the violation of the War Powers Resolution. The policy and the politics, the political success, the policy success made the illegality politically irrelevant. This is true with regard to lots of other issues as well. During the Hurricane Katrina catastrophe, there was a legal dispute about whether it was appropriate for the United States to send troops to New Orleans in order to serve various different law enforcement functions. It turns out that doing so without an express request by the governor of the state violates a 19th century statute called the Posse Comitatus Act. In response to the request that had come not from the governor but from Mayor Nagin, the Attorney General of the United States responded by saying, at the moment we cannot send troops because the law does not permit it. We do not have a request from the governor, and therefore sending troops would violate the Posse Comitatus Act. Whereupon Mayor Nagin said on national television, I don't care about the law, get those troops here now. Similarly, if we look back to a series of events over the last 10 years, we discover that on one occasion, the mayor of San Francisco had married same-sex couples in violation of what was California law at the time. The mayor of New Paltz, New York had married same-sex couples in violation of New York law at the time. The approval and disapproval of those actions tracked exactly underlying approval or disapproval of same-sex marriage as a policy matter and as a moral matter, the fact of illegality played no role whatsoever in the public debate. So now let's step back further and see what's going on. In some areas, of course, law, including constitutional law, is backed by the kinds of formal sanctions that we normally associate with law. Jail, fines, things of this sort. That is, police officers and members of city councils who violate clear constitutional mandates are subject to civil liability in civil rights actions for violating the Constitution. But although police officers, city councilors, Board of Education members, and the like are subject to and frequently the targets of such civil rights actions for violating the Constitution, this does not apply, for technical reasons of immunity and the like, to legislators, presidents, governors, judges, prosecutors, and some number of others. A police officer can be subject to personal liability for violating the Fourth Amendment. A member of Congress cannot be subject to any liability whatsoever for voting for a law that violates the First Amendment. And so too with a large number of moderately high up public officials. What's interesting about this is that at this level, when we are talking about presidents and prosecutors and legislators and the like, when the sanctions for unconstitutional action that might apply to more street-level public officials do not apply, we can ask the question of whether law as law, just because it is law, matters in political debate, matters in terms of political consequences, matters in terms of whether it is something that is an important factor in political decision-making. And almost all of the examples that I've been using up to here are examples designed to suggest that possibly the answer to that question is perhaps no, or perhaps a lot less than many people have thought. Now, in order to think about this question, we have to recognize that the law is most interesting and most important in this regard when it requires people to do what they otherwise would not have done on political or policy grounds. If the law just makes us do what we would have done even if the law didn't exist, or if the law prohibits us from doing what we would not have done even if the law didn't exist, then the law doesn't matter very much. The law has its bite. The rubber meets the road when the law requires political figures to do something other than what their policy and political judgments would suggest. And it seems to be the case more often than we might think that the law matters very little. So, to use a non-political example of this point that I was just trying to make, the laws of the Commonwealth of Virginia prohibit cannibalism. Trust me on this one. If Virginia were to repeal all of its laws prohibiting cannibalism, that would not in any way change my culinary habits. The laws against cannibalism make no difference whatsoever to me. In many respects, lots of laws are like this. Like the laws against cannibalism, they protect against outliers. They protect against the occasional recalcitrant person or the person with unusual preferences. But many laws are important, especially constitutional laws, when they tell people, when they tell political officials, when they tell governmental officials, this may be your best judgment as a policy or a political matter, but best judgment it may be, you are still not permitted to do it. When what an official thinks is right on policy and political grounds is against the law or against the Constitution, what seems to be the case from these and many other examples is that both the law and the Constitution are dropping out of the equation. Now, more importantly, there is some indication that we, as in we the people, don't really care that much. It is clear to me that George Allen and President Obama and large numbers of other political figures are far, far better attuned to the pulse of the electorate than I am. I am not suggesting that any of the actions that I have been describing by all of my examples are important acts of political courage in the profiles in courage sense. Rather, they are the actions of political figures that understand what it is that the electorate rewards and what it is that the electorate punishes. And one of the things that may be the case is that there is remarkably little electoral taste for law as law, as opposed to the electoral taste for the first order primary policy positions. And then we can ask the question, is this a bad thing? If it is the case that the electorate and those who respond to the electorate are interested in first-order substance and, not to use the appropriate philosophical terminology, second-order constraints on first-order substantive decisions, is that necessarily a bad thing? After all, few of us would consider it a bad thing that Abraham Lincoln took the position he did regarding the Dred Scott decision. But then the question is, should we generalize from that, or should we say that this was an appropriately exceptional circumstance? Virtually all of the political figures that I have described, who have progressively denigrated Supreme Court interpretations of the Constitution as binding on them, from Jefferson to Jackson, John Marshall has made his decision, now let him enforce it, to Lincoln, to Roosevelt, to Meese, to Gingrich, to large numbers of others, virtually all of these figures have claimed the authority of Abraham Lincoln. Abraham Lincoln did it in Dred Scott, therefore this is the appropriate way to behave. I don't want to answer the question of whether that is the appropriate way to behave or not on the part of a political figure, because a lot of it depends on the extent to which you do or do not trust political figures to make their own constitutional judgments. But one of the lessons of the 27th Amendment example is that when officials make their own constitutional judgments apart from legal sanctions, their constitutional judgments line up with their political judgments with stunning frequency. Indeed, if we look at the current debates about campaign finance regulation, we have another good example of this. As most of you probably know, the continuing debates about campaign finance regulation, how much you can raise, how much you can spend, how much this can be regulated, whether PACs are wonderful things or awful things or somewhere in between, and super PACs and super PACs, and all of this involves and has involved since the Supreme Court decision in Buckley versus Vallejo a quarter of a century ago, two different issues. One is the issue of, is it, as a matter of policy, a good idea or a bad idea to restrict campaign spending and restrict campaign fundraising? And another issue is, does the First Amendment prohibit restrictions on campaign spending on the theory that spending money is an important way of embodying one's political preferences and political views? Reasonable minds can differ about both of these issues, both about the constitutional issue and about the policy issue. But if you look at the articulated views of the members of Congress, you discover something quite remarkable. Every member of Congress who thinks that campaign finance regulation is a bad idea as a matter of policy also thinks it's unconstitutional. Every member of Congress who thinks that it is a good idea as a matter of policy thinks that it is permissible under the First Amendment. There are 0 members of Congress who think that it is good policy but prohibited by the First Amendment. There are 0 members of Congress who think that it is allowed by the First Amendment but nevertheless bad policy. And if that example is representative, it says something about the extent to which we can trust unsanctioned political figures to distinguish constitutional judgment from political judgment. The Constitution, in my view, is largely not about keeping bad people from doing bad things. It does that occasionally, I'm glad it does, but it's not primarily about keeping bad people or bad officials from doing bad things. Rather, it is about keeping good people from doing good things with good motives because of the larger or longer term consequences of the short-term good things. The mayor and members of the City Council of Skokie, Illinois, who in 1978 tried to keep the American Nazi Party from marching in a community disproportionately populated by Holocaust survivors, were not bad people trying to accumulate power for its own sake. They were good people trying to respond to the felt needs of their constituency, but nevertheless, the courts properly struck the actions down as unconstitutional. Good people doing good things whose actions for longer term or larger reasons violated the Constitution. But if people and their representatives are concerned only with immediate policy, then the point of this whole exercise is lost. If all that we are concerned about is immediate policy or short-term politics, the whole point of having a constitution is lost. We might as well be the United Kingdom or New Zealand or Israel, the only 3 countries in the world without single document written constitutions, and even those are changing somewhat rapidly these days in the face of quasi-constitutional documents and so on. But the classic tradition of those countries is parliamentary supremacy. Whatever the majority of parliament decides is constitutional. We have opted for a different course. But the different course we have opted for will make a difference only if there are political incentives to actually following the Constitution. If the Constitution and if constitutions are a good thing, constitutions are good even when, and perhaps especially, they prevent doing that which is popular right now. But if it always turns out that that which is popular right now for political figures is that which always wins for political figures and for the constituencies of those political figures, then it's hard to understand what the point of having a written constitution is. I will stop at that, and I am delighted to take questions, personal abuse, comments, or anything else you feel appropriate. Thank you. I need someone to, I'm happy to take questions, but I'm not happy to call on the people who ask the questions. No outsider should ever do that. That is, in any group, absolutely any group, larger than 3, there will be people who you don't want to ask questions. Some of them will have pet peeves. Some of them will be people who don't really understand the difference between a question and the speech they would have given had they been asked to give the speech. So I'm not going to call on people, but I'm happy to take some questions.
At the very end, when you were talking
Okay, so it's clearly nothing in what I am suggesting, the 27th Amendment aside, would suggest that the Constitution is or should be rigid. There are huge debates about living constitutions and originalism and varieties of originalism and everything else. One of the reasons that I stress the Supreme Court, and one of the reasons why I use the example I did of campaign finance regulation, is to at least suggest that in most of the areas that really matter, unlike the 27th Amendment, the constitutional text is not going to do very much work. We have a somewhat exceptional Constitution. The Constitution, the new, valuable, and prominent Constitution of the Republic of South Africa, which dates to 1995, is 114 pages long. The Constitution of Brazil is 238. Constitution of the United States is 12. When you understand the difference between 12 and 238, you understand that we have a Constitution that doesn't look anything like the Securities Act of 1933 or the Internal Revenue Code. Most of the action surrounds phrases like equal protection of the laws, due process of law, unreasonable searches and seizures, cruel and unusual punishments, and most saliently right now, commerce among the several states. In many respects, we have such a vague, and vague is not necessarily a term of abuse, we have such a vague Constitution that the interpretations of the Constitution become somewhat more important. One of the things that's happening, and one of the things that's happened in particular with respect to the healthcare litigation and the Commerce Clause, is there are issues that people would previously have thought well settled that are now becoming a little bit unsettled. When you were taking constitutional law from me, anything other than Congress can do whatever it wants under the Commerce Clause would have been a bad answer. That is, with a series of cases that started in the late 1930s, at the end of the New Deal, going up through the cases that upheld the Civil Rights Act of 1964 on Commerce Clause grounds, and a few others after that, made it clear that Congress could do pretty much whatever it wanted under the Commerce Clause. Then two cases that came thereafter in the last 15 years or so, one a case called United States versus Lopez, dealing with something called the Guns in Schools Act, and another called United States versus Morrison, dealing with the Violence Against Women Act, suggested that the Commerce Clause had limits. Once that suggestion was out there, even though there have been a couple of cases more recently that have gone the other way, once that suggestion was out there, I don't fault any member of Congress on one side or another for saying, this is a genuinely open issue. We do not need to feel as if we are doing anything wrong by seeing what the limits are, or indeed even testing the limits. I think that's a very different case from the ones in which the law, whether textually or in terms of overwhelming precedent, all going in the same direction, is clear. I think I saw a hand over there.
Okay, sorry, I didn't see.
Yeah, Professor, I'm happy to have you. It seems like we're looking at the Constitution from a perhaps congressional view of elected official viewpoint and what they do in reaction to that. What about looking on the other side of the curve in politicization of the justices themselves and the highly charged ratification process and what it takes now to get your favorite justice
Right.
confirmed or not, and what they bring to the table to the other side in trying to interpret the Constitution and perhaps other political agendas on the regulation.
Okay, good. one of the interesting things about the Supreme Court of the United States is that most of what it gets asked to do, it doesn't do. What I mean by that is, in the typical year, it is asked to decide about 8,500 cases. It actually decides about 80. So it's worthwhile thinking about the process, not only that produces the 8,500, but getting from the 8,500 to the 80. Once we understand that the Supreme Court is actually deciding only 80 cases a year, we need to understand something that our economist friends call the selection effect. That is, let me use a silly example. I have a dispute with the Internal Revenue Service. In my view, I ought to be able to pay my taxes whenever I feel like it. When I'm good and ready is when I'm going to pay my taxes. The Internal Revenue Service believes that I ought to pay them by April 15th. We have a difference of opinion about this. All of the law is on their side. Because all of the law is on their side, it would never occur to me to make a lawsuit out of this. But once we understand that the easy cases like this don't get into court, the implication of that is that the cases that do get into court are ones in which people can make reasonable arguments, or at least plausible arguments, on both sides. That's the selection effect. That is, a case winds up in a court, and especially in an appellate court, only when two sides holding mutually exclusive views both believe they have some chance of winning. And that's even more extreme in the Supreme Court. What that means is that for the 82 cases a year that the Supreme Court decided in its most recent term, there's either no law at all, or there's lots of pretty good law on both sides. That's not representative of all of law, but these are particularly difficult cases in which formal law, statutes, constitutional text, clear precedents in one direction, do not answer the question. They're hard cases in the classic sense of a hard case. And if they're hard cases on the most politically charged issues of the moment, affirmative action, the place of religion in public life, the reach of congressional power, the scope of presidential power to make war without a formal declaration of war, the most important issues of our time, then the implication of this is that the Supreme Court is deciding cases about which there is no very strong legal guidance one way or another, and in which Supreme Court justices, because they are human beings, are likely to have views about the underlying attitudes, ideology, and so on. Political scientists discovered this about 40 years ago, and people in my profession refuse to recognize it. That is, law professors refuse to recognize what the political scientists 40 years ago started referring to as the attitudinal model. When you get to high salience cases in the Supreme Court, underlying political, social, cultural, economic attitudes make far more of a difference than formal precedent. If you think that's right, and it's plausible for those 82 cases, even if it's not plausible for the normal range of law, if you think that's right for the 82 cases, then you may not think that there's anything wrong about the current nature of the confirmation process. That is, if we think, to take the four most recent examples, if we think that the actual ideological, political, social, cultural, and moral values of Chief Justice Roberts and Justices Alito, Sotomayor, and Kagan actually will make a difference in producing their decisions, and in light of the selection effect, it could not be otherwise, then I don't see anything wrong with a process that tries to expose those views. I see a little bit wrong, or with nominees who, of course, try to avoid answering all of the questions. Chief Justice Roberts said it's just like being an umpire in a baseball game. Justice Kagan said it's law all the way down. We have basically, it's political theater. Maybe it's useful political theater, and maybe it's useful in the sense that it may expose the American public to the actual bases for decisions in this quite unusual, quite exceptional, non-representative court. I'm much more troubled by the politicization of the process of nominating and confirming or not even holding hearings on lower court judges and the like. That, for me, is far more troubling. But this is an issue that the American Constitution does not touch at all. Not surprisingly, given its age. The American Constitution doesn't touch it at all. The Constitution of the European Union, or the quasi-constitutional documents of the European Union, are much more recent and much more detailed. So this in the US is entirely a matter of legislative policy. If the legislature of West Virginia wants to ban genetically modified foods, they can do so. If they don't want to do it, they can do that as well. One of the interesting things about constitutionalism throughout the world is that some issues are constitutionalized in some countries and not in others. For reasons that shouldn't be much of a surprise, language is a huge constitutional issue in Canada and Belgium. It's not a constitutionalized issue in the US. So the issue you raise is very important in the US. It's entirely for legislatures or administrative agencies. In much of Europe, it's a constitutionalized matter.
Yes, many of the young people who are being brought up in this age, by ranking out of college, out of college, out of the world, this is the world we're coming into. So, we're in a recession, we're still tied up with wars in the Middle East. There's a lot of problems, there's a lot of talk that, maybe this, economic model we built up is kind of just going to the wayside. It's all changing very rapidly. In trying to figure out policies, into the future, keeping the idea of, should the Constitution matter? Would at times the Constitution be an impediment to trying to do necessary changes or trying to adjust to this very fast-paced world? Or are we just going to have to just let the Constitution
In a world,
strip it up?
no. In a word, yes. That is, we have an intentionally cumbersome, inefficient Constitution. We have a Constitution whose theory was pretty well captured by James Madison in Federalist 10. If men were angels, no governments would be necessary. It is a Constitution designed to make change very, very difficult. We see it at several different levels. One is the level of how difficult it is to amend the Constitution. We have 27 amendments to the Constitution. 10 of them were added all at one time in 1791. The reason we have so few amendments and nothing of the scope of the 14th since the 14th in 1868 is that you can't amend the Constitution unless you have the votes of 2/3 of both houses of Congress and the approval of 3/4 of the states. But it's even worse than that, because that means that 13 states can block a constitutional amendment. That means that the 13 smallest states can block a constitutional amendment. Moreover, many states require supermajorities to ratify a constitutional amendment. So it turns out that a significant minority of legislators can block a constitutional amendment in any state. And there have been some political scientists who've actually done the numbers on this. That if you look at the number of people represented by the number of people it would take to block a constitutional amendment in the 13 smallest states, you wind up with something like about 80,000 people, or some very small number. And so that applies just to amending the Constitution. The same thing applies to a government of separated powers and divided powers and so on. It is very, very difficult under the American political system to do really horrendous, outrageous, awful things. But as a matter of institutional design, anything that will make it difficult to do horrendous, outrageous, awful things will also make it difficult to do the kinds of things that may very well be necessary. There was a commission about 20 years ago, headed by Lloyd Cutler, who'd been White House counsel for some time, that was thinking about just this issue, and they said, maybe we ought to think about rewriting or redoing some parts of the Constitution so that we can operate more efficiently in the face of a rapidly changing and hugely changing world. Nothing came of it. So I think we are stuck with a risk-averse Constitution which has costs and benefits. And you've just very well outlined some of the costs.
Anyone else out here? Yes, Professor.
Thank you.
Thank you. I have a present for you.
Thank you. Thank you very much. Thank you. And thank you for coming out on a miserable night.